Guns are banned in many public places in New York now that Governor Hochul signed a law that she says gives the state more ammunition.
Though some asking tonight in the wake of all these mass shootings, why would authorities want to make it easier to add guns to the streets?
We are working hard to end gun violence and stop the scourge of illegal guns in our city.
As governor of the state of New York, my #1 priority is to keep New Yorkers safe. But today, the Supreme Court is sending us backwards.
This decision has made every single one of us less safe from gun violence.
The Supreme Court struck down a century-old law in New York State restricting who could carry a concealed gun.
Moral responsibility to do what we can and have laws that protect our citizens because of what is going on, the insanity.
Are not the issue. We have a people violence problems who misuse guns.
Brady United is celebrating in New York right now. They are celebrating the introduction of what's being called Francesco's Law, a so-called safe storage bill that on the surface sounds like it's about protecting kids. But when you actually read the text of this legislation, you realize it is a massive expansion of government authority over how you store your constitutionally protected firearms inside your own home. This bill is almost certainly unconstitutional under existing Supreme Court precedent, and I'm going to show you exactly why. Let me break it down. If you own a firearm in New York, any firearm, a rifle, a shotgun, a handgun, this bill directly affects you. It doesn't matter if you live alone. It doesn't matter if there are no children in your household. It doesn't matter if there are no prohibited persons anywhere near your residence. Under Francesco's Law, the state of New York wants to tell you exactly how your firearms must be stored at all times, and if you don't comply, you're looking at criminal charges. A Class A misdemeanor to be specific. That means up to a year in jail for how you stored your own lawfully owned property inside your own home. And here's the thing, Brady United and the politicians backing this bill are using tragedy as a vehicle. They are using the story of a young child who gained access to a firearm to push legislation that goes far, far beyond anything that would have addressed that specific incident. That's the playbook. That's incrementalism. And that's exactly why you need to understand what this bill actually says.
Though some asking tonight in the wake of all these mass shootings, why would authorities want to make it easier to add guns to the streets?
We are working hard to end gun violence and stop the scourge of illegal guns in our city.
As governor of the state of New York, my #1 priority is to keep New Yorkers safe. But today, the Supreme Court is sending us backwards.
This decision has made every single one of us less safe from gun violence.
So let's get into the text. Current New York law under Penal Law Section 265.45, that's the existing safe storage statute, generally requires secure storage under specific circumstances. Historically, the obligation kicked in when minors under 16 or prohibited persons resided in the home. That's already more restrictive than most states, but at least it was tied to identifiable risk factors. Francesco's Law blows that framework wide open. Under the new language, any firearm owner who leaves a firearm outside of their immediate possession or control, and I want you to think about what that phrase means, outside of your immediate possession or control, must secure it in what New York defines as a safe storage depository or render it inoperable with a qualifying locking device. That means if you set your firearm down on your nightstand and walk to the kitchen, technically under this bill, you could be in violation. If you stage a home defense firearm in a location where you can access it quickly in an emergency, which is exactly what the Supreme Court has recognized as your right, you could be in violation. The previous law at least limited the mandate to households with minors or prohibited persons. This bill removes that limitation and imposes a blanket storage mandate regardless of who else is present in your home or whether anyone else is present at all. That is a fundamental shift. That is the government telling every single gun owner in New York how their firearms must exist inside their own residence at every moment of every day.
As you can see, they say gun-free zone. We do have that video of the NYPD putting up those signs on Wednesday.
Guns are banned in many public places in New York now that Governor Hochul signed a law that she says gives the state more ammunition.
Tonight, the mayor warns the new ruling will put more guns on the streets and put New Yorkers in more danger.
It isn't just a big city problem or a small city problem. It is an American problem.
You'll still have to, if you want to be able to carry a gun, you're going to have to get a license. You'll have to go through a background check, all of that.
Today, the Supreme Court struck down a New York law that limits who can carry concealed weapons.
Now, let me tell you why this is already unconstitutional, and I'm not giving you my opinion here. I'm giving you Supreme Court precedent. In District of Columbia v. Heller, decided in 2008, the Supreme Court struck down Washington, D.C.'s requirement that firearms in the home be kept disassembled or bound by a trigger lock. Justice Scalia, writing for the majority in that 5-4 decision, said explicitly that such requirements make it impossible for citizens to use firearms for the core lawful purpose of self-defense. That's not ambiguous. That's not open to interpretation. The Supreme Court said you cannot require firearms in the home to be rendered inoperable because it destroys the self-defense purpose that the Second Amendment protects. And then in 2022, in New York State Rifle and Pistol Association v. Bruin, the Supreme Court went even further. They established that any firearms regulation must be consistent with the historical tradition of firearm regulation in this country.
A New York state law in New York is now in effect, banning concealed carry guns.
The Supreme Court struck down a century-old law in New York State restricting who could carry a concealed gun.
You cannot tell me this is not a feeling of being surreal. In our city.
How hard would you say it is to own a gun in New York City?
Very hard.
So I ask you, show me the historical tradition from the founding era where the government mandated how citizens stored their muskets in their own homes. You won't find it because it doesn't exist. New York already got absolutely dismantled by the Supreme Court in Bruin. They got told their entire concealed carry licensing scheme was unconstitutional. And what did they do? They came right back with the Concealed Carry Improvement Act, CCIA, which is currently being litigated in Anton Yuk v. James. Multiple provisions have already been enjoined by federal courts. They are habitual line steppers. They lose in court, and they come back with something worse. Now the bill doesn't stop at your home. Francesco's law also creates new requirements for firearms stored in vehicles. Under this provision, any firearm left in a vehicle must be unloaded and locked in an approved storage container and kept out of sight. Every single one of these requirements creates a new criminal tripwire for otherwise law-abiding citizens. You forget to put your range bag in the trunk instead of the back seat. Criminal. Your lockbox doesn't meet whatever specification New York's bureaucrats decide qualifies. Criminal. You're not a danger to society. You're not committing a violent act. But New York wants to make you a criminal anyway through technical violations of storage mandates.
And today, we continue to fight against the flow of illegal guns onto our streets.
The answer is not a lack of consequences for those who commit crimes and being soft on crime.
This decision isn't just reckless, it's reprehensible. It's not what New Yorkers want. Today, the Supreme Court is sending us backwards in our efforts to protect families and prevent gun violence.
The bill also creates an entirely new criminal offense called failure to safely store rifles, shotguns, and firearms when accessible by a minor or prohibited person. If a firearm is stored in violation of these new rules and a minor or prohibited person gains access, the firearm owner faces a Class A misdemeanor charge. Now, yes, the bill includes narrow exceptions. If someone obtains your firearm through unlawful entry, like a burglary, you're generally protected. And there's a carve-out for situations involving lawful self-defense, but those exceptions don't fix the core problem. The core problem is that New York is expanding its criminal code to punish the exercise of a constitutional right. Think about how we treat every other constitutional right. We don't require you to lock up your printing press before you exercise the First Amendment. We don't criminalize how you store your religious texts. We don't mandate government-approved containers for your personal papers under the Fourth Amendment. But firearms somehow. Firearms get treated as a second-class right, and the government gets to dictate the precise manner in which you keep them in your own home. That is not how constitutional rights work.
Moral responsibility to do what we can and have laws that protect our citizens because of what is going on, the insanity.
Are not the issue. We have a people violence problems who misuse guns.
The Supreme Court overturned New York's long-standing gun license requirements.
There are risks that come with a free society. We all understand that.
And there's another provision worth flagging. The bill requires that anyone found in violation receive educational materials produced by New York's Office of Gun Violence Prevention. Now, supporters will say education is valuable, and sure, education is valuable, but firearm education should come from experienced instructors, from responsible parents, from competitive shooters, from military veterans, from people who actually know firearms, not from a government agency staffed by people who are openly hostile to civilian gun ownership in the first place. This isn't education, this is state-mandated re-education for exercising a constitutional right.
That they have taken away our right to have reasonable restrictions. We can have restrictions on speech.
New York City is certainly one of the leading examples of gun restrictions and gun restrictive measures.
We do not need people entering our subways, our restaurants, our movie theaters with concealed weapons. We don't need more guns on our streets.
New restrictions on carrying of concealed weapons in sensitive locations are now in place.
But I will say we are not powerless in this situation. We're not going to cede our rights that easily.
The bill also mandates that state officials collect and analyze data regarding injuries or deaths involving minors and firearm storage. And here's where you need to pay attention to the pattern, because we've seen this exact sequence play out over and over. Data collection leads to reports, reports lead to recommendations, recommendations lead to more legislation, and more legislation always means additional restrictions. It's a ratchet that only turns one direction. So let me give you the honest assessment. Is firearm safety important? Absolutely. Every responsible gun owner knows that. Is teaching children about firearm safety important? Of course it is. But here's the line. The government does not have the constitutional authority to criminalize how you store your lawfully owned firearms inside your own home, especially when the Supreme Court has already ruled in Heller that such requirements are unconstitutional when they interfere with your ability to defend yourself. Francesco's law isn't a safety bill. It's an expansion of state power dressed up in the language of child protection. And Brady United isn't celebrating because kids will be safer. They're celebrating because the government just added another layer of control over your rights. Here's where things stand right now. This bill has been introduced in the New York State Legislature. Governor Hochul has shown zero hesitation in signing anti-gun legislation, so if this reaches her desk, expect her signature. It is not law yet, but given New York's legislative makeup, the odds of passage are high. If and when it passes, expect legal challenges, likely grounded in both Heller and Bruen. For now, if you're in New York, read this bill yourself. Don't take Brady's word for it. Don't take Albany's word for it. Read the text, understand what it changes, and understand how it could make you a criminal for something you do every single day in your own home. Your rights are still intact for the moment, but New York is coming for another piece. Stay informed, stay ready, and I'll keep you updated the moment this moves. That's it for today, folks. See you in the next one.